We're live. We're live. So go ahead. Good evening to all of you. Yesterday we were just discussing section 6. What are the properties that cannot be transferred? To recap, first and foremost is stress succession cannot be transferred. That means a chance of an heir apparent to transfer, a chance of an heir apparent to succeed to the property cannot be transferred. It is something like this: a son who expects his father to kick his bucket at any time. He enters into a sale transaction with a third party and wants to sell the property belonging to his father. This is not permitted under the law because, as far as the son is concerned, he has only got a chance to succeed to the property, though he may be the heir apparent, but it is quite likely that the father may change his mind at any time and always have a feeling that his son is expecting the death of the father at any time. And that is the reason a special succession cannot be transferred. Mere chance of an heir apparent to succeed to the property cannot be transferred till such time he gets the property in his hands. That is 6A. 6B deals with right of reentry. What do you mean by right of reentry? I think perhaps in our day-to-day life, all of us are not fortunate to have own houses. We stay in a rented house. And when we stay in a rented house, we enter into the landlord enters into an agreement with us, and I execute a rental agreement whereby certain terms and conditions are stipulated. In case I violate any of the terms and conditions, it gives a right to the landlord or the lessor to terminate my lease and ask him to be put back into possession, highlighting the violations which I've committed as far as the tenancy is concerned. So here, right of re-entry means that right which is available to only a landlord or a lessor in case of violation of the terms of the lease or terms of the tenancy cannot be transferred because that right is exclusively available only to the landlord or only to the lessor. Third one is right of easement. I told you that in the transfer of in the law of easements, there are two types of heritages. One is called the dominant heritage, and another is called the servant heritage. Dominant heritage is the titular proprietary rights in respect to the property passes on with the transfer of the property from the vendor to the vendee. But apart from that, you got the easementary rights or what is called servant heritage, right of light, air, sanitation, ventilation, right of access, right of ingress, egress, right of worship, right of irrigation waters, so on and so forth. You enjoy that right for a continuous period of you means your vendor enjoys that right for a period of 20 years or more. He acquires a easementary right, that is, his rights cannot be disrupted. That's the reason, sir, when we write a document, we say the vendor hereby sells, conveys, grants all his right, title, and interest in respect of so and so, so and so, along with all easements and appurtenances thereto. Easements means whatever right your vendor had over the neighbor's property by long usage for 20 years period, that right is called an easementary right. A right which you enjoy over your neighbor's property from long usage is called an easement. And once you enjoy the easementary rights, whatever rights you had as a vendor automatically gets passed on to the vendee. That means in case you want to transfer a property, all the dominant heritage as well as the servant heritage has to be transferred. There cannot be a separate transfer of easementary rights apart from the proprietary rights over the property. That is the third restriction imposed under Section 6. Then the fourth one is mere right to sue. Mere right to sue means suppose there's a libel or suppose there's a slander, a particular defamatory article is published in a newspaper which is widely circulated, and your reputation in the eyes of the public and in the eyes of your relatives and friends gets lowered down. Then you've got a right of filing a suit against the opposite side for what is called libel and ask for damages. Slander means, suppose by words of mouth, conduct, or by implication, you insult a person, annoy a person, use abusive words, then you commit an act of what is called slander. Then these rights, which are available only to you because you are the affected person or you are the victim, this cannot be transferred to a third party. You cannot say, sir, in Hindi they say, मेरा इज्जत है तो क्या क्या है, आपका इज्जत है तो क्या, आप डालो दावा. That cannot be done, sir. That is the fourth restriction imposed under Section 6, Clause D. Then the next restriction which is imposed is, for example, I'm sorry, I just elaborate this. Suppose you are asking for compensation for fraud or any harm caused to you. For example, you are being assaulted, or let us say you have been prosecuted for maliciously, or a malicious prosecution is initiated against you. Then let us say it leads in acquittal. And let us say in that case, what you can do is you can file a suit against the opposite side, claiming damages for the malicious prosecution which has been initiated against you in a competent court where the judgment is in your favor. This right is available only to you and not to a third party, and this right cannot be transferred. That is the fifth part, sir. Sixth part is public office or the public salary cannot be transferred. For example, suppose let us say you are a public officer, and by discharging the duties in a public office, you get your salary, or you occupy that particular position. You cannot say, sir, I am the commissioner of the municipality now. From tomorrow, you shall be the commissioner. No, that is why it is said that office is meant only for you and not to a third party, and you cannot make any agreement or any transfer of that public office to a third person. This is the next and the salary which you get as a public officer also cannot be transferred to a third party. That is the next restriction, sir. Next one is stipends and pensions. That is, nowadays they call it as asra pension, which is given to the old ladies or old people who are disabled, who cannot maintain themselves. That cannot be transferred, even if there is a clause, there is what is called a transfer is sought to be made. That transfer is supposed to be void. And then you got one more thing called Act 9 of 1977, what they call it in your Telugu as Leoni Patta, or what is called Lavanya Patta as they call it. This is an assigned land which is allotted to you by the government under the policy of landless poor. This particular D Patta which is given to you cannot be transferred, and even if you transfer it, no registration will be done and it is not valid. But in our day-to-day practice, we see these people are always in need. What they do is they try to pledge it and then try to take a loan. Then next one is there are certain agreements which are opposed to public policy. For example, you cannot sell your house with a condition that that particular house which is sold should be used as a brothel house, and you should attract customers and use it for your sex, so on and so forth. Such a transfer cannot be made for an illegal purpose or for a policy, or let us say it should be used as a gambling den. That cannot be done. Why? Because they are all opposed to public policy. And the last one is subletting. Normally, under the Rent Control Act, subletting is a ground for eviction. But as far as the Transfer of Property Act is concerned, a property which is meant for the exclusive use of the tenant for a commercial purpose or for a residential purpose, that cannot be transferred. If there is a clause prohibiting subletting or assigning your tenancy rights without the express consent of the landlord, that cannot be done. These are all the restrictions which are imposed under Section 6 of the Transfer of Property Act. Then we go to Section 7. Section 7 deals with persons competent to transfer. Please remember, that's what I told you. Though we are dealing with immobile property, the mother of all acts, or the great 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 grandmother of all acts or mercantile transactions, is the Indian Contract Act. Indian Contract Act has given birth to so many children. She has even, the Contracts Act has also got great 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 grandsons also. So the question is, who is competent to transfer? Here, Section 11, I take you to Section 11 of the Contracts Act, which says capacity to contract. A person of the age of minority, a person of unsound mind, an idiot, or a person other who is disqualified from transferring anything or dealing with any property, then in that case they are disqualified. So the persons who are competent to transfer is a person of the age of majority, a person who does not suffer from any disqualifications under the law, they are competent to transfer. That means a transfer can be made only between living persons. The transferor should be alive, the transferee should be alive. Then alone the question of competency or otherwise arises. This is not much of importance. This is what Section 7 deals with. Then we go to Section 8. Section 8 deals with what is called operation of transfer. In transfer, especially instruments, there are two types of transfers. So one is called testamentary transfer, and another is called non-testamentary transfer. Testamentary transfer, I think all of you are aware, that is whatever is bequeathed by a will or a wasiyat or a vilunama is called a testamentary transfer. And when does it take effect, sir? It takes effect after the demise of an individual. A will does not take effect during the lifetime of an individual. And here a distinction has to be made, sir. As far as Hindus are concerned, the will need not be registered under Section 17 of the Registration Act. Registration of a will is optional as far as Section 18 of the Registration Act is concerned. But one important thing you must remember, in a testamentary transfer, what is transferred should be within the disposing capacity of the testator, or if he is a male, and testatrix if she is a female. But a will has to be compulsorily attested by two witnesses. They are called the Shanakat Gawa. That is Sakshulu. Sakshulu is absolutely compulsory as far as a will is concerned. Then how do you prove a will, sir? Please remember, will does not take effect immediately during the lifetime of an individual. When does the will take effect? Will takes effect after the demise of an individual. How to prove a will? Please remember, I think the old act I'm dealing with the Evidence Act, Section 32 or 33, which deals with what is called here, I'm sorry, 134 or 135 of the old Evidence Act, which says attestation. Attestation plays a very important part. Attestation means counter signature of two witnesses who identifies the signature of the testator or the signature of the testatrix, and they countersign it as having witnessed the execution of the document and the signature being put on the will. And one more thing you must remember, sir, in a will, what has to be transferred is a property which is within your disposing capacity. That means you must have acquired the property which you are going to will away. You must have acquired it either by a sale, either by a gift, either by a partition, either by an auction sale, or by any other mode, or a family settlement. Then alone you are competent to execute a document. Then the question of competency comes. Competency means that property should be within your disposing capacity. That is, in other words, in Telugu they say atta somu asta somu alludu danam chesinattu, or lala ke dukan mein nana ki fatiha. That means you are philanthropic as far as others' properties are concerned. When it concerns your property, you become a kanjus. You don't do anything. So the question is, competency of the person is important. That means the property should be within the disposing capacity of the person who executes a will, and then alone it is valid. But here the question is, will has to be attested by two witnesses. Absolutely. And if you want to prove and establish a will, because it comes into effect or takes effect after the demise of an individual, the question is you must examine at least one attestor. One attestor's evidence is absolutely necessary. Here, most of us have got a misnomer. Sir, you take an older person's signature as an attestor, it gives more sanctity. Please remember, you are playing with fire. Why? Because suppose let us the testator is about 88 years old. The attestor whom you have taken, the signature whose signature you have taken is 94 years old. Please remember, the attestor may die even before the testator dies. So the question is, take the signatures of witnesses who are trustworthy, in whom you have got confidence, and in whom you can believe and trust in future. And one more important thing you must remember in a will is the person who is a beneficiary under the will, or he gets a legacy, he is called a legatee. He should not sign as an attestor. In most of the houses, what happens is the brothers try to induce the sister by saying, "Are man tandi garde kada, talli garde kada, santakam pettan." Please remember, if he or she signs, whatever benefit is given to her or him under the document vanishes. No benefit can be conferred. So don't sign as an attestor if you are going to be a beneficiary as far as the will is concerned. Then, sir, what are the consequences? Suppose I get the will registered. If I get the will registered, one advantage I get is it becomes a public document, and it comes within the domain of a public document. The sanctity of a registered will is more believable than an unregistered will. Why? Because you execute the will or register the will before the sub registrar of the concerned place, and the sub registrar also takes your thumb impression on the books in the books, and also on the reverse of it your thumb impression is taken. And now under the amended section rule 32 of the registration rules, the photograph of the testator or the testatrix is also taken, and the witnesses photographs are also taken. Their respective addresses are also mentioned, and you also furnish attested copy of your Aadhaar card, which shows your address and your address proof. They are all absolutely mandatory. But one thing is, in a testamentary transfer, the transfer takes effect only after the demise of an individual, but not during his lifetime. And normally, if you see a will, there's a clause included. This will shall come into effect immediately on my demise, and I reserve my right to cancel or vary or modify this will anytime during my lifetime. So that means, though you write it as a last will, it does not preclude the testator or the testatrix to execute a further will, cancelling the earlier document. And one more contingency is, suppose the earlier will is a registered document, you want to cancel it, it can be only by a registered instrument, it can be done, not by any other means. Then we come to non-testamentary transfers. As far as non-testamentary transfers are concerned, they are sale deed, gift deed, lease deed, exchange deed, so on and so forth. So here, as far as non-testamentary transfers are concerned, we are dealing with that only as far as the law of property is concerned. That means the property which is sought to be transferred should be within the competence of the executant. That means the executant must have acquired the property by any modes of transfer like sale, gift, so on and so forth. And the property should be in his possession, property documents should be in his possession, and he must be enjoying all rights of ownership and possession over the same. And as far as a non-testamentary transfer is concerned, it takes effect. It is not dependent upon the lifetime of the executant, but it takes effect immediately on the date when the transfer is made. But one important thing is, a person who is a transferor should be a person who is competent to enter into a contract. That means he must be a person of a major, a person who should not be a person of unsound mind. He should not be an idiot, or he should not be disqualified by any law for the time being enforced. Then, in that case, as far as a non-testamentary transfer is concerned, it takes effect immediately on the execution and registration of the document. All the titular interest, possessory interest, and all the interest, easement, so on and so forth, which is coupled with the enjoyment of the property, gets automatically transferred to the vendee, and along with the easements and appurtenances attached to the property. So, competent, who are the persons competent to transfer, sir? Persons who are not disqualified. That is, they do not come within the provisions of Section 11 of the Indian Contract Act. The next provision which we deal with is oral. That is, next one is operation. Then next one is Section 9. It deals with oral transfer when that is, when there is no prohibition. Oral transfer. That means, if it's movable property, mere delivery of possession, mere delivery of possession, mere handing over the property, movable property, to the donee or to the transferee is sufficient, because a sale of movable a transaction relating to movable property does not require stamping, does not require registration. And in certain circumstances, there are certain documents which do not require registration, which do not require what is called stamp duty. So the question is mere delivery of possession is sufficient. And this arises mostly in the case of movable property, not regarding immobile property. Except in the case of Muslims, uh, possession can be orally also hiba, they can do the hiba. But one thing is it should be accompanied by possession. Then we go to section 10. That is, section 10 deals with restraint of alienation. What do you mean by restraint of alienation? Suppose I transfer a property to you, I sell a property to you, I gift a property to you, or I do something regarding that property where I disrobe myself and say, from this day onwards, I am not the owner, you are the owner of the property. But it cannot be coupled with a condition, sir, I'm giving the property to you. You have, no doubt you enjoy the property, be in possession of the property, enjoy your title or rights, enjoy your proprietary rights, but under no circumstances you shall sell the property, you shall alienate the property, or you shall transfer the property to anyone else. A restraint cannot be imposed which fetters the right of the purchaser from alienation. Alienation is one of the incidents of a transfer. Please remember, your rights are over. You have sold the property to me. I purchased the property. What business you have got to impose restriction and say, you should alone enjoy the property, you shall not transfer the property to anyone. But this type of clause you normally find in wills. If you see wills, in wills they say that this property is given to my son so and so, so and so, and under no circumstances he shall alienate, encumber, charge, or create encumbrances over the property. Please, or let us say I transfer the property to you and say you construct a swimming pool there so that it is available to the public. It is none of your business to say how I use the property, how I utilize the property, how I make use of the property. Please remember, any condition that is imposed whereby my right of alienation is taken away, it operates as a restraint of alienation and it is void right from the beginning. That is what section 10 says. Then we go to section 11. Section 11 deals with what is called repugnant restrictions. What do you mean by repugnant restrictions? Repugnant restrictions mean that is a restriction which is imposed, a limitation which is imposed, which takes away your right of enjoyment, right of possession, right of title, or right of enjoying the property in any manner you like. Suppose a property is transferred to you subject to a condition that you must marry my sister's daughter. And if you do not marry my sister's daughter, the property will come back to me and the sale shall become void. These are all called repugnant conditions, or a condition is imposed to say that you shall not construct on that property, allow that property to look like Taj Mahal and forever and ever. Though Shah Jahan constructed it for in memory of Mumtaz Begum, Mumtaz Mahal rather. Such a type of condition cannot be imposed, or a condition cannot be imposed whereby you say that you shall you shall construct a cricket stadium at that place where I'm transferring the property to you. Please remember, what way you are concerned when you have sold the property to me, when you have transferred the property to me, when you impose these restrictive, repugnant conditions, the conditions can be ignored and the conditions are void and not enforceable under the law. Then we go to what is called condition making interest determinable on insolvency or attempted alienation. What is the meaning of insolvency? Insolvency is, in your colloquial Hindi language or Urdu language, you say diwala. Here, a person, let us say he has got liabilities exceeding his assets. He is not in a position to pay all his creditors. Or let us say all his creditors are pressing him for payment. Or let us say he has been cornered and whereby he does not know what to do. The only remedy open to him is to go to the insolvency court and ask the court to declare him as insolvent. Please remember, there are two types of deaths that are available, sir. One is called physical death and another is called legal death. Physical death, one who is born is also destined to go. That is, it is said, Thus thou art, thus thou returnest. We have come into the earth, we go into the earth only. That is called physical death. It may occur due to various reasons. But legal death means where you are not able to keep up your commitments, where you are not able to pay all your creditors, where you do not have the wherewithal or the funds to provide money to your creditors or to pay your debts, then the creditors have got a right of filing an IP or what is called insolvency petition before. I think in Twin Cities it is the additional judge city small causes court, Hyderabad, which has got the jurisdiction to entertain all matters regarding insolvency. And once the insolvency petition is filed, the procedure adopted by the insolvency court is a gazette publication. Normally, you file it in the prescribed form, and then a gazette publication is made saying that you have moved an application for being declared as an insolvent, and all your assets and liabilities will be taken over by the officer of the court called a receiver. But in the company law, and I'm talking about the latest company law, that is NCL company law of 2013, whereby all matters before the High Court has now been withdrawn, even for liquidation, etc. You have to go to the National Company Law Tribunal. Previously, the person who is the officer of the court was called the official liquidator, but now they are called the official resolution manager, ORM. That means he takes charge of all the assets and liabilities of the proposed bankrupt, and then administers the property, looks after the property, initiates proceedings for and on behalf of the person who was applied for insolvency, bankruptcy, and then distributes it as and when he realizes the money. That is how the bankruptcy proceedings take place. And bankruptcy is of three types. One is called creditors bankruptcy, creditors winding up, then debtors winding up, or winding up subject to the supervision of the court. So insolvent, the word for individuals is used, the word used is insolvent. But as far as the companies are concerned, or they are called bankruptcy proceedings. And now the High Court has divested itself of all its powers, and all matters arising under the Bankruptcy Act, Bankruptcy and Insolvency Act, still it's called Bankruptcy and Insolvency Act, lies before the National Company Law Tribunal, what is called NCLT, now located at Boromanda near Nagaur. But please remember, if you go to Nagaur and see the NCLT, you can find the bankrupt people coming in Mercedes cars or Rover and all these things. So that is, the candle will be coming to the end. When it comes to the end, it burns like anything. So these people are called bank. But please remember, if you're an advocate appearing for a proposed bankrupt, collect your fees first. Why? Because you will also be included in the list of creditors. You may not get fees later. So this is a precaution you have to take. Here it is said, suppose a condition making interest determinable on insolvency or attempted alienation. What do you mean by attempted alienation? It means a property is given to you. You shall not alienate the property. It's something like taking a cake near the mouth of a child, and when the child is about to take it in the mouth, you just remove it. That is what is called attempted. You give the property to me, you sell the property to me, you transfer the property to me. What I do with that property is none of your business. But suppose, let us say, there's a condition imposed. In case you attempt to alienate the property, in case you try to encumber the property, you are in case you intend to sell the property, the interest is determinable. It will come back to me. Or suppose you are going to be declared as an insolvent. Insolvency petition is pending, and you have been declared as an insolvent. Suppose you become an insolvent, the interest created in your favor will cease and will come back to me. Such a restriction cannot be imposed. That is what Section 12 deals with. Then Section 13 is a very interesting position, sir. That is transfer in favor of unborn persons. Who is an unborn person, sir? I think everyone, all of us are born. We know how we are born. Mother undergoes the period of gestation for a period of 9 months. And if it's a male child, it is 270 days, and it's a female child, it is 280 days. And the Evidence Act also says the period of gestation is 270 to 280 days, whether the mother undergoes the pregnancy. Here, in Latin, there is a maxim called avantra samer. Avantra means where the child is not child is in the womb of the mother. It is called avantra samer. That is, the section 13 says no transfer can. What does the Transfer of Property Act deal with? Transfer of Property Act deals with only transfer inter vivos. That is section 5. That means a transfer can take place only between living persons. Transferor should be alive, transferee should be alive. If the transferee is not alive or the transferee is not alive, there cannot be a transfer. Section 13 says a transfer cannot be made directly in favor of a child which is not even avantra samaya, where the mother is not undergoing the period of gestation or the pregnancy period has not started. Then in that case, mostly there are two communities which celebrate it with a lot of gaiety and pleasure. That is, one is the Vaishya community and another is the Kama community. They are the wealthiest people, if you can ask me. Here, what they do is when a child is about to arrive in the family, they celebrate it with great pomp and pride, like what you found Mukesh Ambani celebrating his son's marriage. The same way, the child is expected, and once the child is expected, what happens is not because the grandparents or the head of the family is attracted towards the child. No, that child is going to arrive and reduce the tax liability as far as the parents are concerned or as far as the family is concerned. And as soon as the child arrives on the scene and the child is conceived by the mother, the child acquires what is called a vested interest. That is, an interest, absolute interest is vested with the child, whatever share is allotted to the child. But the period of enjoyment, period of possession will be postponed till the child attains the age of majority, that is 18 years. So, Section 13 says a transfer cannot be made directly in favor of a person who is not even avantrisa or directly it cannot be made to an unborn person. But for a transfer to be valid, an exception has been made. That's why I said an advocate revels more in the exception rather than the rule. It says first it must be transferred in favor of a person who is living on the date of transfer, and as soon as the unborn child comes into existence, the interest which is devolved on that unborn child will be an absolute interest, though the enjoyment will be postponed till the attainment of age of majority. That is what Section 13 says. Section 14 deals with what is called doctrine of perpetuities. Doctrine of perpetuities mean, please remember if any women candidates are there, please pardon me if I'm going to refer to something. Here, the human greed, the human avarice is to such an extent that no one wants the property to go outside. One of the ways of keeping the property in one's own family is, suppose, let us say, you as a son, you have got a daughter, and you have got a sister who has got a son of marriageable age. Then your daughter is given in marriage to your sister's son. Then suppose the sister has got a daughter. The sister's daughter is given to your son. So what happens is this property goes from one channel to another channel and then comes back. And in Andhra area, especially, there is a custom where I think in Hindi they say Sali Adi Garwali, but here it is Sala Ada Garwala. Sometimes what happens, the brother-in-law lives with the family, and brother-in-law is also he's got the first charge to get married to his sister's daughter, and I don't know whether they say mama, 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 and mama becomes real mama only later. So the question is, he has got the first right or a preemptive right. In Muslims, they call it a preemptive right to get married to his sister's daughter. And ultimately, the mother of the daughter, mother of the girl, is not even the sister-in-law of the girl, but also the question of another relationship also is created where the brother becomes the son-in-law. This has happened regarding a very regarding many people also, sir. So here in South, especially in our area in Tamil Nadu, this sort of practices are very very common. Ichi puchkoda. So the question is, property does not go outside the family. It revolves round and round and round and round within the same family. But the idea of law, or the doctrine of law, is the property should vest in one person or the other at the earliest available time, and there shall not be any indefinite postponement of vesting of property. Why? Because the feudal tenures of the state is involved. Please remember, suppose I go to Mr. Badesa and say, you pay the tax. I have not become the owner, sir. My son has become the owner. My son will be the owner. As soon as my son attains majority, you collect the tax from. Like that, it goes on PD se jate rata. So the question is, law abhors what is called accumulation of wealth in one's own family by various means. Of course, I don't want to describe about the means. So the question is, one of the ways of perpetuating the property within one's own family is to create remote interests. What do you mean by remote interest? Let us say A is the head of the family. He transfers the property to his son. Then son, next grandson, great grandson, great grandson, for PD say PD. That is from generation to generation. What happens? The revenue of the government gets affected. So that is the reason there should be some limit of postponing vesting of property for times immemorial. That is why law says the ownership rights over the property should vest in one person or the other at the earliest available opportunity. And that is the reason why the doctrine of perpetuities has been enacted. Here, doctrine of perpetuities means, of course, this is a qualified right, sir. I think most of you are aware of the judgments rendered by the Supreme Court, where you got one article called Article 19(1)(f) of the Constitution, right to property, right to acquire, dispose of, or purchase property. Restrictions have been imposed, and earlier it was an absolute right imposed. But the question is, after 1975, the famous case of Rajnarayan versus Madam Indira Gandhi, the constitution was amended where they made the right to property as a qualified right, and even the Supreme Court has not interpreted it properly. If you just go through the constitution cases, the first Solapur case, the Shankari Prasad versus Union of India, then Chiranjit Lal Chowdhury versus Union of India, then Golaknath's case, then Minerva Mills case, and the Keshavananda Bharati's case, and the bank nationalization case, that's the R.C. Cooper versus Union of India. In all these cases, the Supreme Court has held the right to property is only a qualified right, and it's not an absolute right. And afterwards, in 1973-76, we had the agrarian reforms. That is, we had the Land Ceiling Act, then we had the Urban Land Ceiling Act, whereby they say no one can hold more than 1,000 square meters of urban land. And as far as agricultural land is concerned, they divide to units. Unit 1, they said, a unit has been defined as husband and wife and 2 children, or 3 children rather. Unit of 5, they can hold together 18 acres of wetland and 30 acres of dry land. Like that, they classified it. So slowly what happened was, right to property has been made a qualified right. It is no longer a fundamental right as enshrined in the Constitution. Article 19(1)(f) of the Constitution is no more existing. So when all these things are there, where is the question of perpetuating the because even a small house I've got, I must be able to safeguard that house. Where is the question of acquiring more property? Only politicians can do it. They can acquire thousands and thousands of acres, whether legally or illegally or by grabbing, so on and so forth. Or a person in defense who was also an ex-minister earlier says that these properties I acquired when I joined politics. I never acquired it when I became a minister. But slowly things come out. We are not bothered about it. So the law says that the seizing in the property, the ownership of the property should vest in one person or the other at the earliest, and there shall not be perpetuation of the property in one's own family by creating remote interest, and that is what is prohibited under Section 14. Here, but Section 14 also makes an exception. It says No doubt, a property can be perpetuated within the family, but any number of life or lives living on the date of transfer plus the ultimate beneficiary, the age of minority. Suppose that ultimate beneficiary is 3 years of age, and he will get the property once he attains 18 years. That is, after 15 years, he gets the property. Beyond that, you cannot transfer it. Are you able to understand, please? But as far as Muslims are concerned, there's a concession made. If the ultimate disposition is going to be made in favor of a waqf or a Muslim endowment, and which is going to the waqf board, if the doctrine of perpetuities will not apply. Then, sir, section 15, the transfer to a class or if interest fails, others remain. Here, suppose let us say a transfer is made in favor of my son's children. Let us say some of them can take it, some of them cannot take it. Some of them can take it because they are qualified. Some of them cannot take it because they are dead and gone. Then in that case, the entire interest will not fail. But those who remain alive, they can take it, and the entire interest created cannot go. That is what section 15 deals with. Then we go to section 16. Failure of prior interest and subsequent interest also fails. Suppose, let us say, transfer I told you is made in favor of an unborn child, not directly, but in favor of a living person. But that unborn child does not come into existence at all. But subsequently, they say future children also. They also, let us say, the mother undergoes abortion after abortion. Children are not born. Then, in that case, both the prior condition as well as the subsequent interest created will go. This is all for academic consumption, please. Section 16. Mother property ఉంటేనేగా దీని గురించి ఆలోచించేదానికి. Here, next one is accumulation. I told you human greed and human avarice is to such an extent. Jama karo. It'll never end. That fellow will kick his bucket also, but still jama karne ka rata. So question is, that is life or lives plus 18 years. Here, even in cases of accumulation, suppose the income arising out of the property is directed to be accumulated and kept in safe deposit, then in that case, that direction for accumulation can be given in the same way life or lives existing on the date of transfer plus a gross period of 18 years is mentioned. Beyond that, you cannot accumulate the income. But there are some properties, sir, which fetches, for example, if you go to the old city, you get, even today, you get a premise, not now, of course, I don't know. You are getting a house for 100 rupees or 200 rupees also rent. Of course, the conditions are very, very bad. But still, if you want to accumulate income of that property, what will 100 rupees fetch? 100 into 12 will be 1200. 1200 into 10 years will be 12,000. The question is sometimes longer period also is mentioned. But the maximum period for which a direction can be given for accumulation under section 17 is any number of life or lives existing on the date of transfer plus a gross period of 18 years. Then next one is benefit of public, religion, etc. That's what I was referring to, waqf and endowment also. Here, suppose it is that is what is called benefit of the public, religion, etc. Suppose, let us say, Muslims are given an exemption that they can accumulate the income and ultimately their children can enjoy the property, and whatever amounts are lying to the credit of the accumulated amount, they should go to the Makkah, Medina, that is to the Waqf board. That can be done. So, as far as Muslims are concerned, the rule of accumulation will not apply if the ultimate disposition is towards the waqf. The next one is vested interest. What do you mean by vested interest? Vested interest means where property is transferred without date or time, it takes effect, it vests on the happening of the event. It must happen or unless contrary. Here, suppose let us say vesting of property, section 19 speaks about when property is transferred without time. See, please remember, the old people in the house are always interested to see that their daughter's daughter is married to their son's son. Why? Because they don't want your grandson, your paternal grandson, that is your son's son, to marry outside. And let us say the girl's daughter, they are not financially well off. So the old man says, right from the birth, they announce that you are going to be man and woman in life. And that feeling will be there right from the beginning. You see movies also, Baba, and God only knows who that Baba is. Here in English, they say cousin. Sometimes you go with your girlfriend also and ask, who is she? Now she's my cousin. What cousin? God only knows. Here, vested interest is, suppose it is said, when property is transferred without the time, it takes effect when it is the happening of the event. Suppose, let us say, A transfers the property to B. In case B marries C during A's lifetime, then if that event happens, the interest that is devolved on this on the son is an absolute interest. But if that event does not happen, vested interest does not take place. But if no time is fixed, when I should get married, what is the time that is fixed? Within what time I should marry? Who I should marry? And what are the conditions I should observe in getting married? If that is not there, then till that event happens, there is no vested interest. So we have finished up to section 19. Tomorrow I shall deal about contingent interest and the difference between the vested interest and contingent interest. Now we pass on to the interaction time. So we have finished up to section 19, please.
One by one, you can unmute yourself.
Raise your hand.
Raise your hands and unmute yourself. Mr. Bade Saab, Mohammed Bade Saab is here. He is the host for today. आ जाइए सर आप He's reluctant to come on the screen. Okay, all right. Any more questions today? Any questions for today? I think no questions for today. All right.
Hello, sir.
Yes.
Sir.
Yes, please go ahead.
Sir, I want to draft a writ petition on Central Administrative Tribunal, sir.
Yes.
Can I have model format, sir, if it is available?
Sir,
In which tribunal, sir, you are going, sir?
Service matter, sir.
Service matter. That is at opposite to Kalanjali.
Cat.
CAT.
What, sir?
The opposite in Hyderabad.
No, sir, in Delhi, sir.
Sir, CAT in the act itself, you have got the rules, the format is given in the rules itself. Only thing is there's not much of difference between a writ petition. It's not called a writ petition, sir. It's called a OA or what is called original application.
Sir, it's just like an application.
Okay,
Or it's also called RP also, sir. There's representation petition. Here, the same format which you follow in the High Court by writing an affidavit in the format and also the petition. That is the only format that is prescribed. But regarding court fee, there is a distinction there. You are not supposed to pay cash court fee. What you do is you will give a demand draft in favor of the Registrar Central Administrative Tribunal along with your representation petition. Then it is numbered as RP. RP means representation petition, or it's numbered as OA also.
Original application.
So the question is, the inquiry which takes place before the CAT is, there are precedents there, sir. Suppose earlier few similar matters.
No. Even the advocates also appear for it. And there are double bench, single bench, everything is available.
Similar matters are decided in a particular way. You can only quote the order, quote the case number and say, in similar cases, this was the order passed. Then the presiding officer says, follow the same order. Please remember, it's easier to practice in the tribunal than practicing in the High Court side. And that experience has shown. Unfortunately, in Telangana, the APAT, which was there, the Service Tribunal for State Government Employees, was abolished during the previous government's time, and now all writ petitions are filed under Article 227 of the Constitution before the High Court. No administrative tribunal exists as far as state government employees are concerned. But as far as central government is concerned, they are called CAT, Central Administrative Tribunal.
So the format is available in the book, sir?
Yes, it is available.
It is available in the book, sir.
Every book, if you see, format is available, sir.
Is as simple as petition, sir. Only some of small amendments, sir. Affidavits and other things will change up.
And only thing is you file the running index, sir, like what you
No,
file.
running index will be that. What do you get? Section people will take care of it. Running index, because they have a separate format of writing in running index again.
Okay, sir. Okay.
And then you are also supposed to be the chronological events also, because the presiding officers are so lazy. They say that they don't
Sir.
want you to go through the entire thing. They say wherever the paragraphs are there, you highlight those paragraphs. 1 minute. Highlight those
Sir.
paragraphs and say, sir, this is the paragraph, line number 14 to line number 18, line number 20 to line number 25. So chronological events you have to give. Without that, and every document which you file by way of material papers or running index should be marked. If you are for the petitioner, you say petitioner P1, P2, P3, P4, and all. Any rulings you are relying on, you make annexure. In the annexure, you say ruling number 1, ruling number 2, ruling number 3 with the citation. Not unlike civil court, where we file list of documents, you don't file list of documents there, but you file what is called annexure. You file running index and give the pages also.
All right, sir. Any more questions, sir? Any more questions for today? Shall I conclude the class for today?
Sir, I just want to make a comment here, sir. I am going at a very slow pace because Transfer of Property Act is a very difficult act to understand. I am not going at a faster pace. The smaller sections I shall try to complete, and then real giant will start. That is specific transfer, right from sale, mortgages, leases, gifts, and then exchange, and then actionable claims. I'll come to it in the end.
Thank you. Thanks for today and see you tomorrow again. Bye-bye.
Thank you.